Welcome to a webinar on Brexit and commercial contracts with UK companies. This is a second webinar that we host from Lydian about Brexit, which is a very hot and actual topic. First webinar took place on Monday and was about HR topics. Today we will discuss commercial contracts and the results of the consequences of Brexit on the execution and enforcement of judgments that you may obtain before Belgian courts or in the UK after the 1st of January in the case of a no-deal scenario. Before we actually start the webinar, just some practical points. The presentation that you now see on the screen, you can easily download it on the download section. You can also ask questions to us. There's a chat function also in this webinar available, and we will reply to your questions after the webinar. And last but not least, we will also ask one question. There will be a poll question throughout the presentation. It will not be a difficult question, but if you answer this question, you will also receive a certificate of attendance. So what is today the webinar about is about, of course, the impact of the Brexit deal or the no deal scenario on commercial contracts. There is no deal for the time being, and what's important, there has been already formal Brexit, but the transition period will end on the 31st of December of this year. So some instruments, legal instruments, will cease to apply as from the end of this year, and the question is whether there will be a deal or no deal. A no deal will be very likely if we follow the news this morning, still the press release from the BBC, less than 50% chance that there will be a deal. There's still some discussion about fishing and state aid, and the position is certainly of the UK that it will be a full agreement or no agreement, and a partial agreement about what's the consequence for applicable law, for the enforcement of judgment is not an option. There's still a possibility of a EU deal, but it's not fully excluded. So also the British members of parliament gave or received a message that they still have to be available between the Christmas recess for a possible vote on a possible deal. But let's see what are the consequences or what will happen in the next days or hours. So what are the potential issues that we face from a commercial point of view with regard to a no deal scenario? Which court has jurisdiction in case of dispute? And we've listed 5 questions. I will deal with the first 3 questions, and my colleague, partner Yves Lenders, will deal with question 4 and 5. So the second question, which law will govern the contract between a UK company and a Belgian company? We will deal in this webinar within the perspective from a UK perspective, but also from, of course, a Belgian perspective and a broader scope, a EU perspective, because there's no real difference between a Dutch company and a Belgian company when dealing with a UK company as from the 1st of January. What if, third question, what if your UK partner refuses to execute a judgment voluntarily? What will happen then? What are the conventions which may be in place? Because that's, of course, important. If you have a positive judgment and you cannot enforce it abroad, then in the UK, for instance, then, of course, all your efforts have been useless. Also, the contractual clauses, the force majeure clause, for instance, but also specific Brexit clause will be important to negotiate it in order to also prepare for potential problems. This is very important. And last but not least, what if your UK partner becomes insolvent? What are then your options or actions that you can take? Of course, first we have to address the legal framework which is currently in place and which will cease to apply as of the 31st of December of this year. And the first important legal instrument regulation is Brussels 1 bis recast regulations, which deals with the jurisdiction in civil and commercial matters, but also with the automatic recognition and enforcement of judgments which were rendered in the UK or in Belgium or in the Netherlands, and which were recognized automatically and also enforced automatically in these jurisdictions. This regulation will cease to apply in relation to the UK. So this is very important. What are the consequences thereof with regard to the jurisdiction? Where can I issue a writ of summons, start proceedings, or if I obtain a positive judgment, where can I execute or enforce this judgment? A second important regulation is the Rome I regulation on applicable law, which law will govern the contract in relation between the UK and a Belgian company. Also, in principle, this Rome I regulation, when the UK leaves definitely the EU at the end of the transition period, more specifically, then of course this regulation will in principle also cease to apply. And then, and that is what Yves will further discuss, is the recast insolvency regulation. What is the impact thereof that this regulation will cease to apply? There are multiple alternatives to these instruments. One is a multilateral or lateral convention, which will or may be joined by the UK, which I will address further on, and also bilateral convention, which may be signed between Belgium and the UK. Currently, there's non-bilateral convention about the topics that we discuss in this slide in place, but maybe there will be, as from the 1st of January, there will be a bilateral convention that will be negotiated between the UK and, for instance, Belgium, but I think that will depend on the end or the result of the negotiations of the Brexit deal. And last but not least, what is then in place is, of course, local international private law. In the absence of any convention, then the local court in Belgium will apply local law, but that will create legal uncertainty both for a UK company towards proceedings or in Belgium, but also for a Belgian company towards proceedings in the UK, because you have to seek advice from a UK lawyer then in order to know what are your rights or what you can expect then from these proceedings and the enforcement from the judgment. The first question, and very important, which court has jurisdiction in case of a dispute? There are multilateral conventions. The first one, which is important in the absence to replace the Brussels 1 bis regulation, is the Lugano 2007 Convention. And the second one is the Hague 2005 Choice of Court Convention. And the title says it all. It's a choice of courts convention. It's limited to the choice of court, which has, of course, important consequences. First, the Lugano 2007 Convention. The parties to this convention are currently all the members of the EU, so minus the UK. And also the EFTA countries like Iceland, Norway, except Liechtenstein. The rules in these Lugano 2007 Convention are quite similar to Brussels 1 bis. There's also the main difference is that the case law of the European Court of Justice only has to be taken into account, so it has not to be strictly followed. And also the choice of court clauses are not so strictly applied, which makes it possible to start proceedings in another state, and then even if there's a choice of court clause, that this may not always be respected immediately. The consequence of the Lugano 2007 Convention is that choice of court clause in favor of Belgian or UK courts remain valid if the UK joins this convention. If the UK would not join this convention, then still choice of clause court in favor of the Belgian courts also remain enforceable before Belgian courts, because one of the conditions of the Lugano 2007 Convention in order to apply is that it should be one of the member states, but also it will only apply if the court which has jurisdiction or before which the proceedings are pending is situated in one of the member states. If the UK is not member to or access to the convention, then of course also the UK courts cannot be subject to a choice of court clause. If there's no choice of court clause, then the rules are similar to the Brussels 1 regulation. Then the principle is that you can only sue the defendant before the domicile where it has its premises, or the place of the execution or delivery, execution of the services, or delivery of the products in the sales relation. Here, the UK already requested accession to this convention, but the problem is that it requires unanimous consent of the other parties, like the EFTA countries, EU, and Denmark. And in any event, it is already too late and will not apply as from the 1st of January 2021, but maybe it will apply later on. But there may be some issues or problems as of the date of the entry into force. But I think that Yves will further discuss this when he's dealing with the choice of court clause that you may have to negotiate and to reconfirm. Second option, in the absence of Brussels I regulation, is the Hague 2005 Choice of Court Convention. And there it's important that the UK requested access, and there's no need for unanimous consent. So the UK will apply as from the 1st of January 2021, which has the advantage that the choice of court clause in favor of Belgian or UK courts remain valid. Certainly for new agreements which will be concluded. For old agreements, there, if you are hesitating to start proceedings because there may be a lapse in time, then based on the Brussels I bis regulation, you can still start proceeding before the end of the year. Then the Brussels I bis regulation will still apply. So that's also strongly advised to do that in order to avoid any misunderstanding or discussion about the application of this convention. The negative side is that it has no rules regarding jurisdiction without choice of court. So no rules with regard to the defendant or the domicile of the defendant, the place of delivery of the products with regard to consumer or employer rights. So then you will fall back on local law, and this will create legal uncertainty. So it's a useful instrument, the convention, but it's limited to choice of court clauses. So these will be upheld in agreements, that's the positive side. But in the absence of an agreement, or if choice of court clause is not valid, then you may face a problem. Second question is which law will govern the contract? In the absence of multilateral or bilateral convention, local, international, private law will apply. And then in Belgium, it's the Belgian Code on International Private Law, which refers to the Rome I regulation, which foresees or stipulates specific rules like the choice of law. In the UK, that's the good news, has also provided and anticipated for continued application of the Rome I regulation in case of a no deal. So for the applicable law, the future rules are quite simple. The existing rules will still apply. So a choice of law, and it's a universal application. So you can choose for not only for Belgian or UK law, but even for law of a state which is not even member to the Rome I regulation. So a choice of law clause in favor of Belgian law or UK law will still be valid. Nothing will change. And if there's no choice of law, then it will be the domicile of the party who provides the most characteristic performance. And this is obviously, for instance, in a sales contract, it's the seller. And then it will be the law where the seller has its premises. This will not change. So your choice of law clauses in your agreements between the UK and a Belgian or another European country will in principle still be valid as from the 1st of January. This will not change and is still important or very important for companies. The third question, important, we have first dealt with the jurisdiction and the applicable law. If we then obtain a positive judgment, then you of course also want to enforce this judgment if your UK partner refuses to execute a judgment voluntarily. Then we also have to rely, in the absence again of the Brussels I bis regulation, which provides for automatic recognition and enforcement of judgments, we have to rely on again the two conventions that we already mentioned, but also we can rely on a new convention, the Hague 2009 Convention, which is not yet entering into force, but is also possible that the UK will also request to access this convention in the near future. What is the Lugano 2007 Convention? Like the Brussels I regulation, it also sets a uniform set of core rules on recognition and enforcement of judgments. What is important is that it does not apply to insolvency judgments, and the accession should be requested by the UK. And like we said also for the jurisdiction, it will also require the unanimous consent of the other parties or the other member states to this convention. So let's see what will happen with regard to the Lugano 2007 convention. The Hague 2005 convention, the choice of court convention, there the advantage was that it was clear that choice of court clauses were still valid. But the negative aspect thereof is also that only judgments issued on the basis of a jurisdiction clause, that these will be recognized and be enforced in the UK or in Belgium. Here the UK has requested accession, and this convention will apply as from the 1st of January 2021, but it has a limited scope. Therefore, the Hague 2009 convention, the new convention, has a broader scope. It also applies in consumer and employment matters, and it's also possible then that the UK would access to this convention due to the limited scope of the Hague 2005 convention, which would create more legal certainty. And then if no new convention would apply, and the UK would not access to any other convention, and there would also no bilateral convention between the UK and Belgium, then we have to rely both Belgian company has to rely before the Belgian courts Belgian law, UK company before the UK courts on UK law, on local international private law, which will be applied by the local court. And then we have to see what is possible in order to enforce or execute a judgment rendered before a UK court in Belgium. Then we will have to rely again, like it was before and like it's now today, if we want to enforce or execute judgments from the US, from China, from Jersey, which is also a specific regime. Then we have to obtain a sort of exequatur that you have to request the President of the Court of First Instance to recognize the judgment, and then you can ask your bailiff to enforce it. Of course, this will create legal certainty because UK companies does not know what are the exact rules in Belgium, but also the other way around. When a claim is brought before the UK courts, should be maybe before in the UK, just when you have a positive judgment in Belgium and you want to enforce it in the UK, you will have to rely on the UK code on private international law. And for this, you may have to seek advice from a UK lawyer in order to enforce a judgment. And of course, it's better to seek this advice before starting even the court proceedings and also assessing the risks thereof. We have, after these three questions, a poll question with regard to the applicable law question. And the question is, will a choice of law clause appointing UK law in the contract with your UK partner be valid as from the 1st of January 2021? And the answer is yes, or only if Belgium and UK sign a bilateral agreement. No, such clause will always be invalid. I leave you some time and I will pass the floor in the meantime to my colleague Yves Lenders. Thank you.
Waarom niet drukken?
Op de muis en op het scherm. Op de presentatie.
Waar de presentatie?
Ja.
Oh, apologies. Thank you all. Thank you, Jo. Allow me to introduce myself. I'm Yves Lenders, and I will be talking about the specific contractual clauses to be revisited in view of the, let's say, hard Brexit. I must click here. Yes, of the hard Brexit, and then on, let's say, the insolvency. Yes, insolvency impact. So, in view of Brexit, which contractual clauses should you renegotiate ahead of a future dispute or negotiate today for new contracts you will enter into with a UK partner? You already pointed out the exclusive jurisdiction clause, which will become or will be enforceable under the Hague 2005 Convention, so the choice of court convention, And there it's important that to avoid legal uncertainty, because of the entry into force of that convention only in January 2021, that you would reconfirm that jurisdiction clause in existing ongoing contracts. So to be certain that that clause is entered into under the application of that Hague Convention. In the absence thereof, there can be a discussion of whether the choice of clause, the choice of court clause is valid under the Hague 2005 Convention. The alternative is obviously the arbitration clause, because the hard Brexit, the Brexit as we see it now, will not affect the validity of such clauses and or the enforcement of awards rendered under in arbitration in a dispute between parties. The arbitration clause indeed is under the application of the New York Convention. The New York Convention, where it's a UN convention, where the individual members or parties have adhered to, accepted them, irrespective of their, let's say, EU situation. So there is no problem as to the enforcement of the agreement. There is case law specific to the New York Convention, recognizing the agreements, the forms, etc., to fall under arbitration. And secondly, it gives you the basis for indeed recognition and enforcement in the signing states of the New York Convention. So that's about exclusive jurisdiction. Choice of law, basically, as you indicated, it's lesser a concern, as basically the same rules apply, will continue to apply both in Belgium and the UK, but it's never, let's say, it's still advisable to insert that in your contract, as there also, my advice always, you can only negotiate your contract if you know under which law you are working and you are negotiating. But that is lesser of importance as a direct consequence of the Brexit. I will get this following slide. Yes. Yes, force majeure clause and a material adverse change clause. So you are familiar with that. Both clauses enable contract parties to exclude from or suspend performance of one's obligations under an agreement upon the occurrence of a certain defined event outside the control of the party. And force majeure will apply, for example, Belgian law, even without a contractual clause. We see, for example, and our position is the same on both, that there are also sometimes material adverse change clauses, which are kind of a hardship clause, and a MAC clause, we see it in acquisition and lending agreements. For both clauses, it's quite uncertain and even unlikely that they will and can be triggered due to Brexit. It will depend obviously on the drafting of those clauses specifically as they are in the agreement, but they are mainly drafted for unexpected events rather than for unforeseeable events. So it's important to look at the definitions that you have of both events in both the force majeure clause and or material adverse change clause in your contract, to see indeed whether the Brexit and the consequences of Brexit, because basically the consequences are the most important ones, and you cannot renegotiate based on force majeure or suspend based on force majeure if your specific duty, your specific obligation is not affected by the Brexit changes. So you have to see in detail what the consequences are of Brexit for a specific performance of a contract. So for example, if you're going to write on force majeure, it might be that you have to include, for example, the change in the EU procurement regime, which will no longer apply. Then that could have an impact on the performance of your contract. So your MAC clause or your force majeure clause should look at that. So indeed, an alternative to that, which is not on the slides, note that on the Belgian law, we do not know the concept of hardship, which is mostly included in UK contracts. I mean, contracts written from the UK. So where there is indeed an imbalance between the obligation of the parties due to certain unforeseen, unexpected circumstances. There also indeed the unexpected and uncertainty is an important element to look at the definition thereof, to be able to negotiate a new contractual arrangement due to those consequences of Brexit. And then you see sometimes indeed a Brexit clause, oh, we should include a Brexit clause in our new agreements, which has been already done, let's say, the prior year and even since 2019. And there is the question or the attention to be given whether you will draft a general Brexit clause or a specific Brexit clause. So indeed, the clauses expressly take into account circumstances in which Brexit-related evolutions impact a party's capacity to meet its obligation under an agreement or significantly increase the cost of execution. So while it is certain that Brexit will lead to substantial modifications in the legal and commercial environment, the details of such changes are not yet known and will differ from contract to contract, business to business. So when drafting such a clause, you have to try to strike the right balance between general and specific elements. If the clause is defined too widely, the non-affected party would face the problem that the clause is easily triggered. So that is invoked very easily, trying to breaking up basically the contract because of Brexit, but basically there is no affection. The specific task obligations are not affected. But indeed today, as the actual impact is still unknown and uncertain, we don't know. It will be there a deal, will be no deal, will be there, let's say in January, February, March, still partial agreements between the UK and EU member states individually or with the EU. Your clause has to be flexible from that point of view, but should be indeed specific in order to avoid such a large escape route for your contracting party. Another important element is obviously agreements with territorial scope, for example, license agreement, distribution agreements. And there we have to check whether indeed, if, for example, the contract is geographically limited to the EU, it has to be verified and checked whether it refers to the EU member states from time to time as they evolve, the member states come in, go out, or whether indeed there is a specific definition of the list of EU member states at the time of contracting. If in the latter event, the UK will still be part of the contract because it is strictly defined at the time of contracting, and therefore the exit of the UK from the EU will not have an effect on the geographical scope of the agreement. You could say, indeed, if you're going to draft it right now or specify it now in your existing contracts with mutual consent, or indeed new contracts, it's also important now to keep already in mind the possibility, and I'm not doing any political statements, about UK membership. For example, what will be the position of Scotland within the UK? So indeed, when the UK is defined as a territory in a long-term contract, it might indeed be wise to plan ahead this possibility and amend your draft accordingly. Should the territory be UK as today, or should it also be, as with the definition sometimes of EU member states, the EU members from time to time make the preference clear? Another important element is obviously, and there we go to the essence, is price and costs. You have to see that you have price adjustment mechanisms. Again, if you agree to a price, it's a price. If transportation is included, it is included. And if you do not provide any contractual arrangements, then the price is basically fixed. And without a hardship clause or a MAC clause or a force majeure clause, which is effective and clearly to be implemented, the price will be there will be no room to amend your price in the contract. So indeed, increases of tax treatments, changes in foreign exchange rates, transportation costs, custom and duties should be verified and included, because again, certainly on the Belgian law, there is no exit, no possibility to renegotiate your contract based on Belgian law unless we have an agreement on that. Against all that, it's important to check your contract on liabilities, because indeed, if you have a contract of a short-term contract and you have little or no liabilities, and you limited your liabilities significantly in your contract, then okay, you conclude a new contract and there is, let's say, an exit for you there. And in that view, it's also important to consider basically whether consequential damages are, yes or no, excluded under your contract, especially whether the damages that your contracting party would incur because of your breach of contract is included in your contractual liability, because it could indeed, as you might know, if you deliver something and it is resold in the UK, then there are additional liabilities that you are not really expecting perhaps today. I see that I have to ask a second poll question for the famous certificate. I'll see that I can bring it up to the screen. Which clause should you renegotiate with your UK partner? You have 4 options, so please click on the correct option. People are voting. We take the poll for 40 seconds, which is advisable, and I see that 71% have voted, and I see that we have terminated the poll question, and indeed the majority said all of the above, and there are indeed 10 and 10% who point out to the important clauses, the jurisdiction and choice of clause law clause, and the Brexit territorial scope and price adjustment clauses. But indeed, all of the above should be indeed reviewed to determine your, let's say, to-do, if not yet done, for your contract review and contract amendments for new contracts. So I turn to stay also within a time limit, the final question: what if your UK partner becomes insolvent? We know today we have the insolvency regulation. We have recently the recast, which deals with indeed pan-European insolvencies, both restructuring proceedings and bankruptcy proceedings, which is a mechanism that quite well works. It has a mutual recognition, and even, as you know, with the Comey principle, it is today still possible that a UK court can declare a Belgian legal entity bankrupt or open certain insolvency proceedings if that Belgian legal entity has a center of main interest in the UK. So with the exit of the UK, this will no longer be applicable, and we cannot rely today on any multilateral or bilateral conventions between EU, Belgium, and the UK. So we have to rely, from our principal point of view, on our Belgian Code of Private International Law. That set of rules determine what to do with cross-border situations. First, important, Belgium will still recognize insolvency proceedings initiated in the UK if the principal establishment of that company, legal entity, was indeed in the UK. Then we will, in Belgium, have to recognize and will recognize the effects thereof and all the enforcement against Belgian debtors, etc. And the UK law will indeed open that opened indeed insolvency proceedings, will govern the rules on the declaration of debts and claims and the payout to the various creditors abroad as well. The impact is also on the execution of the assets of the UK debtor will be recognized in Belgium. However, a little bit like the insolvency regulation, there might still be Belgian local proceedings that can be started in Belgium if the UK company has an establishment in Belgium. So that the so-called local proceedings, which we know from the European insolvency insolvency regulation, so that indeed an establishment of a UK entity in Belgium can be declared bankrupt in Belgium under Belgian rules. However, the scope of that insolvency proceedings will be limited to the assets of such an establishment located in Belgium. So the most important change we will see is that there is no threat, no forum shopping that we see sometimes for a UK court to declare a Belgian legal entity bankrupt or open certain insolvency restructuring proceedings against that Belgian company. So there, from our side, we will not recognize that influence, that power from UK courts, as we will still do under the regulations from the Netherlands or from Spain or France. With this, I conclude our little, let's say, update on Brexit, what it means on commercial agreements and the impact thereof. There are a lot of tips and tricks, I think, so don't hesitate to contact us for your specific situation. We will have in our Brexit series from Lydian, as you might have seen, on the 12th of January, IP and data protection, on the 19th of January, corporate and finance, and to conclude our series on the 26th of January with our real estate and environmental and regulatory department. So for now, I think I stayed within the time. I wish you a nice weekend, and notwithstanding the virus that apparently is around there, I wish you splendid festive seasons and a Merry Christmas. Thank you all.